Hello, this is a brief talk on the law of 22 Prairial. On the 10th of June, 1794, 22 Prairial by the Revolutionary calendar, Georges Couthon, speaking for the Committee of Public Safety, brought a law before the National Convention meant to speed up trials by the Revolutionary Tribunal, the court created by the Convention in 1793 to try political crimes, crimes that undermined the war effort or sought to overturn the Republic and restore the old monarchy. The new law, which we will discuss in just a moment, was the outcome of a process that had started with the 1792 September massacres in Paris, when the people of Paris had set up irregular courts to empty the prisons before the men of Paris marched out to help stop a Prussian advance on the city. These courts had sentenced to death around 1,200 men and women. From that point forward, we can say the majority of the deputies to the National Convention wished to prevent irregular massacres of this sort. They sought to replace them with the rule of law. It was recognized by them that France was full of traitors, and that these traitors had to be punished. The question was how to set up a court system that worked quickly and efficiently enough to prevent further uprisings. This matter took on increasing importance in 1793 as the Federalist Revolt and the War in the Vendée appeared, making it clear that the existence of the Republic itself was in question. From March of 1793 forward, communities throughout France had to deal with increasing numbers of suspects being imprisoned and awaiting trials. Local courts gummed up, and the National Revolutionary Tribunal could not handle cases fast enough to empty the prisons. The result had been the creation of a variety of special courts in the provinces that could handle political crimes. In April of 1794, the Convention decreed that all political trials were to be held in Paris under the Revolutionary Tribunal to ensure that justice was done and local rivalries eliminated from the pursuit of justice. The many local courts handling political matters were to be wound down. In part, this decision reflected the fact that exceptional courts to handle political crimes in the provinces were no longer as necessary, as the Federalist Revolt had been quashed and the War in the Vendée had switched to a smoldering problem rather than a full-on conflict, and that the Republic had enjoyed increasing success in its war with Europe. Nevertheless, the decision to relocate all political trials to Paris made the delays in trying and sentencing or acquitting suspects even worse. The law of 22 Prairial was an attempt to streamline the process further, to eliminate delays, and above all, to punish the enemies of the Republic. As Couthon said when he proposed the law, it wasn't just meant to punish the enemies of the people, the law was meant to annihilate them. So let's take a brief look at the law the Committee of Public Safety brought to the Convention. What did it propose to do? First, it reorganized the Revolutionary Tribunal's size and how it was divided so that it could handle more cases more quickly. Second, it declared that the only purpose of the Revolutionary Tribunal was to, quote, punish the enemies of the people, unquote. It followed this flourish with an expansive definition of what an enemy of the people was. Enemies of the people included anyone who sought to destroy, insult, or undermine the National Convention or the government of the Republic. Anyone who had betrayed the Republic, who was in the army, or who corresponded with enemies of the Republic, or who disrupted provisioning of the army. Anyone who gave aid to the enemies of France. Those who deceived the people or their representatives in order to harm public liberty. Those who discouraged the French people in order to assist foreign enemies. Anyone who misled the people, who undermined the energy of the Republic, including journalists who reported false news, any contractors with the government who acted in bad faith, and people in public office who used their office against the interests of the Republic. In effect, anyone who had either conspired against the Republic or tried to prevent the Republic from becoming strong enough to win its wars was to be considered an enemy of the people. There was to be only one penalty for all convicted by the Revolutionary Tribunal under the law of 22 Prairial. That penalty was death. The right and duty of every citizen to denounce enemies of the people to the authorities was emphasized by the law. Every citizen was required to report, quote, conspirators and counter-revolutionaries, unquote, as soon as that citizen knew about them. To repeat, the Revolutionary Tribunal was to handle the trials of anyone accused of being an enemy of the people, and the only penalty for those convicted was to be death. The crimes I've listed are a bit vague, and it would be difficult to prove, for example, that a military contractor selling the army shoddy goods was actually trying to help England win the war, for example. It's entirely possible that such a man was engaged in simple fraud. The definition of enemy of the people, though, was broad enough to include such common criminals, accusing them of weakening the Republic in time of need. The same was true of black marketeers, journalists, gossips, drunks, just about anyone. All that was necessary was to claim that a person's actions weakened the Republic or assisted its enemies in some way in order to convict a person and have them condemned to death. A very broad range of actions became subject to the jurisdiction of the Revolutionary Tribunal through this law. The law of Prairial then modified the trial procedure that the Revolutionary Tribunal would use. While it was still going to be a jury trial, the standards of evidence were lessened. Evidence was taken to be anything, quote, material or moral, oral or written, unquote, which could lead to a conviction by a just and reasonable mind, a mind focused on the triumph of the Republic and the ruin of its enemies. The point of the change in standards was to speed up the trials, to allow for the tribunal to hear more cases. Therefore, all written materials were disposed with where possible. Witnesses were only to be heard if there was insufficient material or moral proof presented to the court. Moreover, legal counsel would be denied accused conspirators coming before the tribunal. As soon as pleas were entered and evidence heard, the jury was to render a verdict and the judges to declare a sentence. Once someone was denounced to the tribunal, a prosecutor had to bring the case forward. In cases where the prosecutor felt there was insufficient evidence for the charges, he had to write a report, and the tribunal would decide whether or not to hear the case. However, in no event would a person be discharged without the case being examined by the Committee of Public Safety and the Committee of General Security. To be clear, according to the law of 22 Prairial, once one had been denounced, one would be tried, except in the most unusual of circumstances. When one was tried, one would most likely be convicted, and if one were convicted, one would be executed as quickly as possible. The law of 22 Prairial turned what had been admittedly a politically motivated court that convicted about half of the people brought before it, to one which had lacked a clear procedure that could ever result in the acquittal of someone accused. The law of 22 Prairial was meant to speed up the execution of those thought or even imagined dangerous to the survival of the Republic, regardless of the evidence against them. And it did speed up the process. The new law led to more death sentences in Paris during the 7 weeks while it was in full effect from mid-June to late July, around 1,500 sentences, considerably more than had been given in the previous 14 months in Paris. It was during this period, too, that the social composition of those executed in Paris changed rather dramatically. From June to the end of July 1794, the proportion of former nobles and clergy executed in Paris surged, as did the number of wealthy members of the Third Estate. So many people were killed in such a short period of time that the guillotine had to be moved twice to new locations in increasingly remote areas of the city to deal with complaints by local constituents about the amount of blood being spilled and the fear that the spectacle might trigger sympathy for the condemned among the Parisian populace. In fact, as the tribunal took the lives of men who were socially more and more like the deputies of the convention, those deputies became more and more frightened. In the end, the law that was meant to strengthen the hold of the convention and the committees over the justice system, and through this, over the government, became a major reason for overthrowing the committees themselves.